Welcome to Employment Law This Week. I'm George Whipple. It's August in an election year, but things haven't slowed down at all on the regulatory front. Federal agencies and the courts are working to figure out how things will change now that Chevron has been overturned. But today, we'll turn our attention to the states. We'll look at 4 states where government action is impacting employers. First up, Massachusetts. The Bay State is the most recent to enact a pay equity law. The law establishes new pay range disclosure requirements for employers that employ 25 or more employees in Massachusetts. Employers that employ 100 or more employees in the state and are subject to the EEOC's EEO-1 data reporting requirements must also submit a copy of their EEO-1 data reports to the state. The first reports are due February 1st, 2025, and the requirements for disclosing pay ranges take effect on July 31st, 2025. Now to Illinois, where a new law has softened the edges of the state's biometric privacy law. The new law limits penalties under BIPA and clarifies consent procedures. Employers can now only be held liable for a single violation per person, rather than for each alleged use of biometric data. Illinois was the first state to enact a biometric data privacy law in 2008, and the law had led to extensive damages awards. Now, the legislature has limited the damages that can be recovered in a BIPA suit. In Michigan, employers will have to reckon with a new decision from the state's Supreme Court, which reinstated 2 laws that had been created through a public initiative and provided for annual increases to the minimum wage, a gradual elimination of the wage differential for tipped workers, and expanded paid sick leave obligations. The court determined that the state legislature's actions to weaken these laws were unconstitutional. These changes in Michigan, including the first minimum wage increase and the expanded sick leave provisions, will now go into effect February 21st, 2025. Among other changes coming to the sick leave law, employers with 50 or more employees will see an increase in the amount of leave that can be accrued and used, up from the current cap of 40 to 72 hours per year. And in Florida, a federal court permanently blocked the state's Stop Woke Act, which restricted workplace DEI training after the state said it would not appeal an 11th Circuit ruling upholding the temporary injunction. And a different federal judge in Florida overturned the state's ban on transgender health care, ruling that the state's Department of Management Services violated Title VII when it excluded certain treatment options for transgender employees under the state-sponsored health benefits plans. And that's just a sampling of what's happening at the state level. Thank you very much for watching, and we'll see you next time.